Okay, I think I am live there now. Hopefully I am. You might just confirm, if you wouldn't mind, that you can hear me okay and that the sound is okay. Thanks for joining me on this live stream, Ask Me Anything on Sunday. But you might just confirm, as I say, that the sound is okay. I want to knock it off here.
Yeah, I am. You might just confirm, if you wouldn't mind, that you.
Okay, we'll take a look at your questions now. I presume I'm okay. Frank Trapp says you can hear me. That's fine, that's good. So firstly, hello to Ross Z from Drogheda, to Dwayne, Blake, Mary Finn, Nicholas, Rizos, Frank Trapp, Skilt. Thanks for joining me. Hello, and I hope you're having a good weekend so far. There's a lot of interest apparently from the number of questions that are coming in, so I might just get stuck into them straight away as best I can. First question there from Ross is to do with property prices. What's your short, mid and long term view on Irish property prices or property markets? I'm planning to purchase my first property in 6 to 12 months time. It's very, very hard to say, Ross, and you'd want to be very careful about taking any procrastinations or prognostications or forecasts from observers, whether they're economists or solicitors or doctors or anybody else. Clearly you have a requirement to live somewhere. You need to live somewhere. You may have a growing family, you may have an employment situation which allows you to buy a property. The question for you to address, I think, is probably whether you want to continue paying rent or perhaps living at home, which may well be the case, or buy a property. If you're going to buy a property, and assuming that it's not for pure investment purposes, that you're going to live in it and enjoy it as a family and so on and so forth over the next 5, 10, 15 or 20 years, it's probably a sound and good and sensible and tax efficient investment. So as to the short, medium and long term view of the situation, I'd take any forecasts with a grain of salt, quite frankly. If you need a house, go ahead and buy one, and you probably get a bit of value at the moment, especially with the COVID-19 situation ongoing. So that's what I would recommend you do. And the next question there is from Dwayne Blake. I'm from England. Your channel is brilliant. You've taught me a lot. Thanks, Dwayne. Glad you find it useful. Mary Finn, hi Terry, thank you for sharing your knowledge. I have a question relating to deductions from pay. Can an employer or public sector deduct overpayments from your wages when the calculations are wrong? Yes, absolutely. There's no difficulty whatsoever with doing that. All the employer has to be careful about is giving you sufficient time, reasonable time, I suppose, to make the repayment. So it depends to what extent you have been overpaid. But the bottom line is it's similar to or analogous to an ATM machine spitting out 50s rather than 20s. The money still belongs to the bank. It's not your money and it will have to be repaid. And all you can really hope for, I believe, is a bit of time and perhaps some sort of a reasonable repayment plan and time period over which to pay it. But that's what you're stuck with. Now, the next question. Similar to or analogous to. I want to just turn off the volume there on my computer because it's off-putting. Just give me 1 minute.
It's not your money and it will have to.
Yeah, okay, we're good to go there now. Nicholas Rizos then is asking me, why would the negotiation process be deliberately delayed by defence in civil litigation? Total disregard for effective communication. Ego, maybe. Ego shouldn't really enter into it. The reason that you might drag your heels and drag your feet in terms of defence and civil litigation is it can frustrate the other side. And obviously, if you have a strong case, you have a strong claim, and you're happy enough to push ahead and so forth, then clearly time is going to be a critical factor or an important factor for you. But for the defence, if there's no defence or if there isn't any valid defence, then there may be a serious concern. So clearly the longer that they drag it out, the better to a certain extent. Obviously costs will become an issue, but it may come to a point where it becomes very frustrating for the claimant or the plaintiff, and perhaps it might encourage the settlement talks, or it might encourage some sort of a compromise arrangement. So that's one of the reasons why you might delay or drag out your defence or any aspect of the negotiation or any aspect of the litigation rather. I see Skilt there and Mary Finn, Max, Yana Gogova. Hello Yana, how are you? Skilt says property is going down, but that's not my experience, and I am dealing with properties on a daily basis, quite frankly, and we're closing deals. I'm closing deals this coming week and closed a deal there last week, and the prices actually haven't changed at all so far. I'm not saying that they won't change, but it is a possibility, there's no doubt about that, but I can't see it. Skill says employment is down, bank lending is going to tighten, a building pipeline increasing. Yeah, that may well be the case, but I mean the economy probably will recover. It will be slow, obviously. The COVID-19 pandemic situation has to evolve and sort itself out, or be sorted out over a period of time, and obviously it depends on how long that takes. But if you're going to buy a property and you're going to live in it and you have a half decent job and you might be working, for example, as a school teacher or in the HSE or as a public sector employee, then you've got safe, sound employment. If your partner or your spouse also is employed in gainful employment and in secure employment, then, and you intend living in a particular place, you're happy enough there, your job is there, and you're going to buy a house and live in it and enjoy the benefits of buying your own house and not paying rent and enjoying the society of your family and your wife and so forth over the years, then buying a house now or 5 years time or 10 years time, it won't make a huge amount of difference in the overall context, I don't believe. Worker number 674829 likes or loves my channel, thank you. Can a workplace use the COVID crisis to get rid of troublesome staff? Not legally, no, but they can use the COVID crisis as cover for redundancy. And obviously, in fairness, a lot of employers are going to have a difficulty with the economy as a consequence of the COVID-19 situation, and it is not difficult to see how an employer can put forward proposals for redundancies and justify them. I mean, let's face it, there's a pub down the road there for me. I live in a small rural area in County Kildare. Our local pub hasn't been open since, I think it's Paddy's weekend, and it's an appalling situation for that pub, or indeed any pub. Most pubs are suffering very, very badly. So obviously, if redundancies were to arise and the pub game was fatally hit and things didn't recover, well then clearly redundancies are going to be inevitable. Max, my company asked me those questions last week. I'm not sure what questions you're referring to there, Max. And hi Terry, brilliant content on your channel. Any advice for a mature trainee attending PPC1 this year? How do you see law firms operating in the next few years with the COVID situation? Don't know about that, and I wouldn't be a great man to be giving career advice, quite frankly. My own career is kind of spotted. It's like a curate's egg. It's good and bad in places, but the bottom line is, if you have a bit about you at all, then you could make yourself a career as a solicitor, or indeed in any profession, provided you are seriously committed to it and you really want to be whatever you're committed to. But clearly it comes down to the individual and the willingness to do the commitment. And let's face it, I'm doing okay now, but I'm doing a live stream here on a Sunday. The sun is splitting the stones outside. So, you know, if you're self-employed or you want to achieved something or succeeded something, you do have to make the effort, you do have to do the work, and you do have to do work that's half useful, you know what I mean? And a lot of people comment on my channel and say that it's great and they're delighted with it, and there's students and so on, and they think I'm the bee's knees. But the bottom line is, and let's be clear about this, I create every single video on this channel, well, not every video, but most of them, to get clients. And that's how, you know, how it come about, and that's why it's that's why I do it, you know. As for the law firms down the line, not 100%. Danny Murphy, how does temporary wage subsidy scheme affect an employee's holiday entitlements? I understand that if they're on the subsidy scheme, and obviously they're on the subsidy scheme, then clearly they're still working, they're not on layoff, they are being paid, then I believe they're accumulating holiday entitlements. I mean, clearly they could be doing the work, or probably are doing the work, or should be doing the work. If they're on layoff, that's a different situation. They don't accumulate holiday entitlements when they're on layoff, but layoff is not the same as the subsidy scheme. I hope that answers your question, Danny. Frank, on the WSS paid minimum wage doing all my hours, so I'm getting a rate below the MWR of pay. Should I pursue a case to the WRC? I can't really answer that one, Frank. That person, whoever it is, and I know it's not you, it's up to themselves whether they pursue a case to the WRC or not. But in any case that they might pursue to the WRC or anywhere else, they must weigh up two things: A, the possibility or the probability of winning, and B, the potential payoff. So you sit down with a pen and paper, quite frankly, and you calculate what you might win if you were successful, and then you obviously get advice from somebody like yourself or somebody like me who's in the game to assess their chances of succeeding. Edwin Letterkenny, presumably, if you're a victim of an assault in Ireland, can the Garda force you to cooperate? That is, if requesting an interview, can you legally refuse without fear of arrest, or can you bring a lawyer? Edwin, I'm not 100% what you're asking there, but just if you say you're a victim of an assault, they may want to investigate it, because it's in the public interest that the Gardaí try to prevent and apprehend violent assaults and assaults on people. Okay, so if you don't want to get involved though, and if you were the victim and the guards want you to be a witness or to make a statement or something, quite frankly, you're not going to be much good to them if you are an unwilling witness or won't give evidence. So from their perspective, and indeed from your perspective, you are probably you're not much use to them, quite frankly. So if you don't want to participate, if you don't want to take it any further, if you don't want to make a complaint, if you don't want to give evidence, if you don't want to attend for interview, then that's, you know, your own choice, and you can do that if you want to. Clearly the guards will be disappointed insofar as they want to pursue somebody for an offence, and clearly it's in society's interest that somebody is not allowed to go around willy-nilly offending people. But it's your call. The bottom line, as I say, I'm saying to you, is if you're an unwilling witness and you don't want to be involved, you're not much good to the guards, and they'll probably drop the pending charge if there is a pending charge. Paul John, thanks for all the good work you do. What is the best thing to do if you have been left go while on long-term sick leave? Depends very much on the circumstances, Paul John, but if you're capable of working again, I would suggest you try and get another job. I know that may not be the advice you want, and I know that may not be good legal advice, but it will depend on all the circumstances of how you were terminated, whether you were discriminated against by reason of your illness and so forth. I mean, clearly there is probably a backstory there, a significant backstory, and I have pursued relatively recently a case where a fella was terminated whilst he was out sick, and we pursued the case and we won 2 years salary for discrimination under the Employment Equality Act, but every single case is different, and it will depend on your particular circumstances. So I don't want to be trite, or I don't want to be too simplistic, but it will depend on your situation. You may have a claim, you may not have a claim, and sometimes you might have a claim, but it may be the best thing to do is put the whole thing behind you and move on. But I'm not saying that necessarily in your case. I simply don't know. Max, can you employer to contact tracing in your phone? Antibody testing, temperature checks. My employer asked recently last week. Contact tracing in your phone, antibody testing, temperature checks. There's a whole lot of issues going on there, Max. I can't answer that question specifically or with too much detail. What I would say is that in the public interest and in light of the guidance from the Back to Work Safely protocol from the Department of Health and Employment Affairs and so forth, certain steps have to be taken by everybody, including employers. So the contact tracing situation on your phone, I know I have a log in my office at the moment, for example, which allows us to take the name and telephone number or contact details of everybody who comes into my office now, and we do that in order to provide contact tracing if it arises. Now, clearly there might be a GDPR or data privacy issue arising from that, but this particular spreadsheet was supplied to us, or to me, I got it from the Law Society website. So clearly the GDPR issues or the data protection, data privacy concerns must be assuaged in the mind of the Law Society, presumably, and in my mind then, and in the public interest, it obviously there's certain curtailment or certain modification of rights and so on and so forth, simply because of the sort of emergency or whatever, and there is emergency legislation brought in there relatively recently. So what, Max, exactly you're asking me there, I don't know, but what I am saying is we're kind of in an unusual, exceptional sort of circumstance, and contact tracing seems to be a good thing and in the national and public interest. So Edwin Letterkenny, I think your video on carry water, chop wood, save my mental health. Well, that's good. It's not too often I get such strong ringing endorsement, and that makes my work certainly worthwhile. It gives me a great sense of satisfaction. I wouldn't mind, but that particular video wasn't even about law. It was just about the need to put distractions aside and put them away and focus on work that matters, that focus on the stuff, focus on the relationships that matter to you. So that's what the whole Zen Buddhist philosophy of chop wood and carry water is about. So to recap, if you want to gain enlightenment according to a Zen Buddhist philosophy, you should chop wood and carry water. And if you want to retain enlightenment, what do? You chop wood and carry water. In other words, you do the stuff that matters, you focus on the work that matters, and you put aside all sorts of distractions. For example, social media sites, YouTube, mobile phones, and so on and so forth. But I'm glad that worked out for you, Edward, or Edwin. Frank Trapp says, have you done any remote hearings with the WRC or Labour Court? I haven't done any yet, Frank. No, it'll be interesting to see. We got something there last week, all right, and obviously some cases are more suitable for remote hearings than others. So that's something that's interesting, and it will be interesting to see what cases are suitable. It must be, obviously we'll have to look at that down the road in order to get cases on and get them heard and get them sorted out. But Jesus, it's going to be awkward, I would imagine, especially if you're looking at 2 or 3 or 4 witnesses and they're all over the place and maybe they're in the same room or what. I don't know how it's going to work. So haven't done it yet, Frank. No, I don't know what the story is there yet. Worker number 674829 had an accident at work. Or if he had an accident at work. This is a hypothetical question, worker number, whatever, and you'd raised health and safety concerns and pursue a case. Do you get protection as a whistleblower? That is retaliation. you get protection under the Protected Disclosures Act 2014 if you're penalised for having made a protected disclosure. However, a lot of people misconstrue or misunderstand what a protected disclosure is. Most of them, quite frankly, are grievances or complaints, and sometimes I've come across, would you believe it, that are just big fat whinges. So they're not protected disclosures at all. Now, you bring up health and safety concerns, and that's fair enough. And if you have genuine health and safety concerns, by all means, you would be protected under the and have protection under the Protection of Disclosures Act 2014, whatever it is, and you shouldn't be dismissed and you shouldn't be penalised. But it's a difficult case enough to win sometimes, because you must prove causation between the disclosure that you claim that you've made and the wrongdoing that you then allege you suffer, and that flows obviously. The two, there must be a strict connection or causation link between the two. And as I say, it can be difficult, and then some other people, quite frankly, some employees try to use the Act to protect them or to bring claims which may not stand up. In other words, they may have been dismissed or fired for different reasons. Jesus, there's a rabbit gone tearing across the front there. They use protected disclosure as an excuse for having been dismissed, when in fact it turns out, when you get down into the weeds and get the nitty gritty, get the detail, that there was actually a long protracted performance issue, or there was various issues to do with misconduct, or perhaps one incident of gross misconduct. So that's the story there. Dragonborn 2K. Hi Terry, love the vids. I'm 19 and currently training to be a pilot. Good stuff. My goal is to invest in property as early as possible. For someone of my age, where could I learn more and get the knowledge I need? That's not an easy question, Dragonborn 2K. Look, I don't know where you're going to get the advice. I don't know where you're going to get the sound investment. Obviously, most places or most sources of information or good knowledge, etc., will come from books, will come from people who have travelled the road before you, people like, people who have invested successfully and so on. So I would recommend first getting some solid books. You'll see books there behind me, and I have a good few books about property investment and serious analysis of property trends, prices, comparisons versus investing in the stock market and so on over a period of time, the real return versus the nominal return, and so on and so forth. So the books are out there. You would be well advised, I think, to go onto Amazon or someplace, or go to your local bookstore, a good bookstore, and get some books and read them, but make sure that you are getting information from reliable sources, people who are expert in their field, not bullshitters and charlatans and chancers who purport to know about property markets and investment and so on, because there is an awful lot of grifters and strokers out there. Hope that helps. Edwin Letterkenny, if you have a specific legal issue, even if your legal practice is not local to your county, and if so, can you do a Zoom interview with you, pay up front by PayPal? Yes, you certainly can. I do consultations and interviews, but consultations by phone, email, in person or video, and I do Google Hangouts, I do Skype, I do Zoom. There's no difficulty there. And you can pay in advance, and we take credit cards over the phone, or you can pay by PayPal or do a bank transfer. Yana Gogova, hi Terry, I'm your fan, love your videos. Thank you, Yana, you're very kind. That's good. I like your video, or I like the fact that you appreciate my work, etc. It's great that people do actually appreciate the work. And to be honest with you, it's not the most interesting, or it mightn't be the most interesting to most people. Most people might think that law is boring and business is boring, etc. Well, that's fair enough. They might think that, but the bottom line is, some people are excited by it, and some people have an interest in it. Some people have a passion in it. And what I like about that lady, Jana Gogova, liking my videos, I see there that I have now got 6,950 subscribers to my YouTube channel, and I am a one-man band. I have this mobile phone, and I've got a few other little bits and pieces, but I've no production team. I've making YouTube videos since 2011, and it gives me a right good feeling of satisfaction that there's nearly 7,000 subscribers to this freaking channel. That gives me a kick, you know, a real kick, a real thrill. Alex John, what is the chance of going against the Air France here in Ireland for something happened abroad? I'm an Irish citizen and resident as well. I'm not sure, Alex John, what you're talking about there. I mean, if against Air France here in Ireland, well, if the incident occurred here in Ireland, I mean, it depends exactly what happens. I mean, it depends whether it's a breach of contract situation or a personal injury or some other form of litigation or whatever. But the bottom line is there's court rules there about jurisdiction and where claims or where legal proceedings are to commence and so on and so forth. So there's no difficulty taking on Air France, but sometimes, you know, if you're going to the High Court or anywhere else and you're taking on the bloody airline, you want deep pockets, you know, or else you want solicitors and barristers who are very confident about winning and will do the thing on a no-fault, no-fee basis or something like that. So, but there's no difficulty in theory, but whether it's an advisable, smart, astute thing to do is another thing, you know. Frank Trapp says, what's your opinion, if any, on the extension on the emergency legislation in terms of redundancy? Seems only in favour of the employer and not the employee. And any thoughts? Yes, Frank makes the point there about the emergency legislation that was brought in there, the COVID-19 emergency legislation. And there's a particular section in it which prevents employees who have been laid off or put on short time from availing of the Redundancy Payments Act 1967 to claim redundancy. And the reason for that, obviously, is the employers are going to be fleeced by a buttload of redundancies that they mightn't be able to pay for, and ultimately the state then is going to have to pick up the pieces. So what happened there was the state brought in the emergency legislation, suspending effectively for the period of the emergency the right of the employee to claim redundancy. Whether it's going to be extended or not, I don't know. Frank, you might know yourself whether it has or not yet. I think it's to run out this weekend or thereabouts, but after that, clearly it's not in the state's interest. I suppose that's the view that they took, that there would be an absolute raft of redundancies with people claiming redundancy as a consequence of being laid off. So that's perhaps the thing. Joshua Everett is telling Dragonborn 2K to join the group Property Investors in Ireland on Facebook. So that's something that you might want to do, Dragonborn 2K. Mary Byrne, if an employer has officially made you redundant by phone, email and an attached letter, can a later... Mary, you were in touch with me about this already and I explained the situation to you, so that is the position. You obviously haven't availed of what I was offering you there, so... Worker 67482, and just to go back to you, I mean, the bottom line is you contacted me a couple of times about that particular situation and I left it with you. You didn't come back to me. So citizens information though are very useful, are very good, and they are free. Worker 674829. I studied law about 15 years ago and I'm now considering a career in law in my mid-30s. Is clerking along track work following? Not sure what you're going to do there. You must be going to become a law clerk or whatever. Look, if you want to become a solicitor or a barrister, well and good, but you need to focus. I'd be inclined to put the hard work in early and make a real burst for it. And if you do qualify as a solicitor or as a barrister, then at least you have a chance to make a career out of it. But being clerking for a long period of time, I'm not sure about that, to be honest with you. Rufus Ryan, are employers obliged to cover medical costs of employee if accident happened at work? Well, Rufus, what generally would happen there is the employer, if the accident happened at work, the employee is going to bring a personal injury claim against the employer. And before I do that, I want to go back to that question there by Mary Byrne. If an employer has officially made you redundant by phone, email and an attached letter, can you later retract? Yeah, I'd need to see the attached letter. I need to see the letter, Mary, to be honest with you. Yeah, Rufus Ryan, medical costs of employee if accident happened at work. Thank you, sir. The bottom line is, Rufus, that if you have suffered an accident at work, it's open to you to bring a personal injury claim against your employer. That would be on the basis that you are claiming that the employer was somehow negligent and therefore is liable for the injuries. If the employer is negligent and is liable for the injuries and all of the damages that flow from that, then down the line the employer is going to pay medical costs, etc., because he's going to pay all special damages. So in the meantime though, oh, this fucking thing is going up here so fast now. Where are we at all? Yes, back here now. So the bottom line, Rufus Ryan, in relation to the personal injury claim there, is if the employer discharges your medical costs now, etc., he might do so on the basis that you might take a more favourable or benign view of him in relation to bringing a claim, quite frankly. So he might be hoping that you won't bring a claim against him, and that's entirely your choice. I mean, if it's a Mickey Mouse or a small claim, it mightn't be something that you're going to do. Maybe you will, maybe you won't. That's entirely up to yourself. Obviously you need legal advice and you need a medical report, but he might pay your medical costs with a view to persuading you, quite frankly, to not bring a claim. But bottom line is, at the end of the day, if you do bring a claim and if you're successful, then your medical costs will be discharged by the employer. I had a personal injury claim pursued by a solicitor started 3 years ago. Third party didn't communicate with PIAB. My lawyer hasn't even got a first court date. Says he has 6 years. Is this normal? Depends on the particular situation. Monica Ixer, Ireland. Can't comment on that particular case. Your employer or your solicitor, though, should be able to explain exactly where you're at there. There may be a perfectly valid reason, or there mightn't be any reason at all. I don't know. I'm not going to defend this solicitor or any other solicitor, quite frankly, or anybody else for their work. They're quite capable of doing that themselves, and they don't need me. You've paid all the fees required, just exasperated. What's the usual time frame for these claims in Ireland? Well, I don't blame you if you've paid all your fees. I don't know what the state of the play is, but I mean, just to be clear, if you bought an injury board claim, a claim to the injuries board, and you either had an assessment there that was accepted by the other side, or the other side didn't accept the assessment, or the injuries board felt they couldn't make an assessment, and they issued you then, or your solicitor, you, with a letter of authorisation allowing you to bring legal proceedings. It's up to your solicitor then to instruct counsel, quite frankly, to draft legal proceedings, bring them and push the thing on. So that's entirely up to yourself. But you should inquire from your solicitor what exactly is the situation, what stage you're at, what's the state of play. Jana Gogova. Hi Terry, does DAAH, I don't know what that is, Jana, has been extended until the 10th of August 2020. Frank Trapp tells me that the emergency legislation has been extended until the 10th of August 2020. Okay, fair enough. Satnav, what's the smallest piece of land you've ever been sold? Looking for a half or quarter acre to start a little casual gardening project out the country. How would one go about finding such a piece of land? Oh, I don't know, Satnav, how are you going to do that? I mean, if you call around to any local farmer or any farmers in whatever part of the country you're looking for, obviously call into a local farmer and by all means ask them would they be interested in selling a bit. I mean, I live in a local area or a rural area here. There's only a few houses around the place, and you know, it may be suitable and it may be convenient for a local farmer to sell a bit of land, maybe a bit of land down, you know, in an inaccessible area or near the bog or something that will be of no great interest to them, and maybe there's $5,000 in it for them or $10,000 or whatever, and might suit you for your garden, your vegetables, etc. That's up to yourself. You need to shop around. I mean, clearly those sorts of sites probably won't be advertised, so you're better off probably knocking on doors. That's quite frankly, I think, the situation. Worker number 67 4829. I recommend your channel to everyone. Thank you. I appreciate it, and I appreciate everybody who A, likes this video, B, likes all the other videos, and C, encourages people and shares my videos and so on and so forth. It's good to get the feedback, you know. Michael Kelly, if bringing a claim against a company for breach of statute under sale of goods and supply of services, providing the product is under £2,000, can this be dealt with in the small claims court? Off the top of my head, Michael, I am not sure, but I think so. And I think if you're a consumer, there shouldn't be any difficulty there. I think that the small claims court situation is administered by the district court. So what you should do is contact your local district court, tell them what you have, tell them what you want to do. But if you go to the court's website, that's courts.ie, go to the office location of your local district court, ring them up, dial and smile. They'll tell you what the story is with a small claim situation, but I think it goes into the district court. Can I email to you? You certainly can, Mary. Yeah, no problem. Air France, my wife was denied boarding into the plane at Belgrade even though producing valid boarding card. Subsequently endured hardship for more than 7 days, and that was the last plane out. Well, Alex John, it really depends on the reason why your wife was denied access. There's fairly good reasons for denying access onto aircraft. I mean, clearly it's in the interest of everybody and safe travel that there's rules and regulations about getting access and so on and so forth. So the bottom line is I couldn't advise you on that particular case, but there was hardship, etc. With last plane out, there was hardship for 7 days or more than 7 days. So you might have, obviously, you've out-of-pocket expenses, or she had, and she had to be put up somewhere else, and she had to stay in some other hotel or some other accommodation or whatever, and perhaps incurred the cost of change flights, etc. If there was a breach of contract, or if there was a breach of statutory rights, well then by all means you could bring a claim against Air France, alright. And it may well be possible, if you're an Irish citizen, to do it here. I'm not sure. I think there is some sort of an airline ombudsman or some sort of a office here in Ireland that might deal with claims like that. So maybe have a look for that first. See is there an aviation ombudsman or airplane or airline ombudsman in Ireland, and take it from there then and see can you pursue it, you know. Edwin, without going into your own details, but it's difficult to get Google to monetize a small YouTube channel so you get paid for the videos. I could get paid for these videos if I wanted to, because I'm actually approved now for advertising, but you'll notice my videos don't have advertising, and that's because I don't really want advertising, because quite frankly it's Mickey Mouse money, it's a pittance, and it's annoying as well for people who are accessing my videos. And in the game that I'm in, all I need is one client or one consultation or one house sale or one house purchase, which will more than make it worth my while to make the videos and so on. So quite frankly, I could turn on monetization if I wanted to. I did turn it on for about a week, but the money was so bloody bad that I just turned it off again. So it's Mickey Mouse money. You'd want huge numbers of videos and huge volume of viewers in order to make it worth your while. If you find this video useful now, don't be afraid to give it a thumbs up down below, alright? Can a workplace use their lack of health and safety reports, paperwork, use that to their advantage and say an accident at work never happened? No, they can't. I mean, the obligation is on the employer to maintain records, and they have a duty of care then when it comes to negligence. They have a duty of care when it comes to employees. There's a standard of care that they must meet. There's health and safety obligations. There's health and safety obligations arising from statute, the Health, Safety and Welfare at Work Act, whatever year it is, and there's also common law obligations to look after the employees and provide a safe place of work. So it wouldn't be to the employer's advantage not to have reports. Now it might be to their advantage if they buried a particular report, in other words a specific accident, and denied that it ever occurred, if that was the case, and if they were somehow trying to claim that the accident didn't occur. And obviously you're going to have a difficulty then if there was no witnesses or no evidence of the accident. But in general terms, you go into court with one arm as long as the other, and you're an employer, and an accident has occurred in the workplace, and some fella is claiming that he's after losing a limb or something, it's not going to be to your advantage as an employer to say that you don't have any records. Frank Trapp, how to carry out a disciplinary procedure in the Irish workplace. Your online course, is it updated? I want to do one, but want one that is updated and relevant. No, it's not updated, Frank, but the principles, quite frankly, are the same. The principles of doing a disciplinary procedure is pretty much the same insofar as there's been no change in the legislation, and there's been no change in the common law principles, and there's no change in the constitutional principles. So fair procedures, natural justice, put the allegations to the employee, give the employee the opportunity to explain their side of the story, explain themselves, put the evidence to them, let them test the evidence, and so on and so forth. All of those things remain the same now as they were in when I made that course. I'm not suggesting you should buy it, it's up to yourself, but the principles surrounding the conduct of disciplinary situations and proceedings are pretty much the same. As a general question, if the courts are not sitting at the moment, will any of the claim time limits be extended because of the current crisis, or these hard legal limits? I'm not sure now about the time limits there, but I'm not sure about the time limits. But I think there was some provision, there might have been some provision in the emergency legislation that was brought in there to allow or to extend the time limits, etc., etc. Not 100% about that, to be honest with you, and I'd be spoofing if I made it up. If you Google it online, you'll see, I think there was some question there though, and there was obviously a concern for solicitors, and the Law Society as well dealt with it and discussed the question of bringing, for example, personal injury claims. I mean, there is a statute of limitations there, and one of the first things that you'll do if you are involved in a personal injury defence situation is you'll claim, if the other side are out of time, that they're out of time, and that's it. The case can't proceed. So that is the bottom line there. Off the top of my head, I don't know. I know there was some debate there, and there was some concerns raised by solicitors in the Law Society about that. Questions are drying up there now. If you find this video useful, as I say, give her the thumbs up down below, because it encourages me and it encourages other people. Edwin Letterkenny, is there a difference between a criminal law solicitor and a civil solicitor in Ireland, or can any solicitor take on any case and access the courts? Any solicitor can take on any case and can access any court. So I, as a solicitor, can access the District Court, Circuit Court, High Court, Supreme Court, and I have a right of audience in all of those courts. Whether it would be sensible or not for me, and whether it would be sensible or not for somebody who is accused of a crime to instruct a solicitor who doesn't do much criminal law, I don't think it would, quite frankly. And the solicitor may be slow enough to take on the case as well, because obviously he would be rusty and may not be absolutely, or she may not be absolutely familiar with the nuances of the particular offence. And that's why everything that I do all sorts of law in my office in Enfield, but I don't do criminal and I don't do road traffic, and I don't do those because, well, I don't do them. And the bottom line is that anybody who contacts me with a criminal charge or a criminal issue and want representation or road traffic, I just say I don't do it, and I send them elsewhere, because they'd be better off, better served by going to a local solicitor in the district court who spends all his or her time there and does criminal law and knows the judge and knows the law, but most importantly knows the judge. They say in the district court you're better off knowing the judge than knowing the law. Now, that's not an aspersion on judges or anything, but what I'm saying is human nature is human nature, and every solicitor who spends a lot of time in the district court will know that every single judge has his own particular take of things that he likes and dislikes, and has his own particular way of running cases, and has a particular consistent pattern of, you know, being really, really dismayed and angered by particular types of crime, whether that's speeding or whether it's drugs or whether it's whatever. So that's why I would recommend you go to a solicitor who does a good bit of criminal and spends all his time, quite frankly, in the district court. Dragonborn 2K, have you any interesting stories about issues arising out of simply purchasing a property, or even with regard to tenant landlord fallouts? Well, I have some absolutely shocking bloody stories about landlord tenant fallouts and buying property. I had one property there where the sale closed, and unfortunately the people hadn't left the house, so I was acting for the purchaser, and the solicitor acting for the vendors hadn't told them that the sale was closing, and so I closed the sale with the other solicitor, and the keys were released, and they called round to the house, my purchasers, my clients, and discovered that the vendors were sitting in the dinner or in the kitchen having their dinner. That got awkward. In relation to landlord and tenant, some landlord and tenant situations, I've been in a few. I've been in one where I landed down at a rental property I had and discovered that the tenant had been arrested and taken to Castlereagh prison a number of days prior, and there was a little dog left in the apartment and had the leg chewed off the table. And I had some other desperate situations with tenants in apartments as well. Good tenants now, but it is a difficult situation when you get a tenant who is essentially antisocial, or perhaps suffers from some mental difficulties, because they can do a serious amount of damage to your property, and it can be difficult to deal with tenants in Ireland because there's a fair degree of protection for them, courtesy of the Residential Tenancies Board and so forth, you know. Worker 674829. I want to sincerely thank you, Terry. Thank you. I've had a couple of tough years. Watching your channel blog has got me interested in law again, to the point I want to work in the field. Well, that's good. Good for you anyway. Can you comment on medical misdiagnosis? No, Mary, I can't. I mean, that is such a broad topic. If somebody's medically misdiagnosed, and if there is negligence involved, well, then clearly it's a medical negligence case, and you bring a personal injury claim against the person who is guilty of the misdiagnosis, and who ultimately, I presume, you'll be holding liable for damages and for injury and so on and so forth. But medical negligence cases can get expensive because you're looking at expensive medical reports and so on. So it's a specialist area, medical negligence. Any intentions to write any new employment law book or guides, etc.? Not just at the moment, Frank. No, I haven't. The other book, or the book that I have, sells quite well. I have a couple of books out there. I have Employment Law in Ireland, a guide for HR managers and employers or something like that, or employees, and I have 31 cases, and both of those books actually sell quite well. I sell a copy or two every single day, and I have done for some time. So I have no intention of doing any further ones just at the moment. I might do something else, but Jesus, finding the time to do all this and make videos and write blog posts and so on and so forth is time consuming. So I have no intention of doing anything just at the moment. But to be honest with you, if I wanted to, I do know that the interest in law is such, and interest in cases is such, that I would be able to do a book, I think, on cases, specific cases that have occurred, and simply draw lessons from those and publish it, and I think it would sell well. In fact, I know it would sell well, because there is a fascination there. People do have an interest in cases, and people, obviously being humans and have human nature being what it is, are interested in looking at their own situation through the prism of somebody else taking a punt for unfair dismissal or discrimination or whatever. So there is a huge interest in it. So if I was going to do a book, and it has crossed my mind, another book, I'd be thinking about some sort of a cases book. In other words, bog standard or bog straightforward lessons you can learn from these cases, etc. I know that sell well, so there's a tip for you. Foot clinic. Sorry, Terry, did you miss my question, or did I miss your answer? I missed your question, yeah. Foot clinic. I don't know what the question was. Let me see now. Can I find it here? Foot clinic. What's your question, Foot clinic? I didn't see any question there at all from you. Do you see it on the screen? Because I don't. Foot clinic. Now, Monic Axer, Ireland. If you take a civil case against someone, is the case heard where you live or where the defendant lives, and who decides? The rules of court determine or set out where you can bring a case. You can decide, so it depends on whether it's breach of contract or a debt collection situation or negligence or whatever. So every particular area of law will have rules of court which will determine where it can be brought. It is possible in relation to, for example, contract, to bring it where the contract was formed or where the defendant is from. Different principles will apply to different cases then, personal injuries and so on. Personal injury can occur, I think, where the injury occurred or where the plaintiff lives. I think, although maybe just where the plaintiff lives. Bottom line is, your solicitor will tell you, but make sure to bring it in the right place. But if you're not bringing it in the right place, the likelihood is that your proceedings won't be issued in that particular court. They'll just bang them back to your solicitor and tell you this is the wrong court. But having said that, you'd want to get advice on that, you know. When Paul Cooper, hello Paul. Stephen Duffy, hope you're all well. Well, I'm doing the finest, Stephen. I'm getting hungry now. I have 10 minutes to go and I am gagging for a sandwich. Paul Cooper says, when a solicitor gives a percentage of fees at the start of litigation in writing, can this be changed due to the length of the case, or can they change the way they charge for the length of the case? Paul Cooper, you'd want to look very closely at the letter you would have received, but generally the letters that you receive setting out either the charges or an estimate of the charges or the basis on which they're going to be charging will be drafted in such a way that there's a fair degree of flexibility there. In other words, there may well be a proviso or a condition there that if the shit hits the fan, quite frankly, and it takes on a life of its own, the solicitor may be covered. You want to look at the letter. It used to be a section 68, I think, letter. Now it's a different sort of a thing. It's a different arrangement. We have to be very detailed about the basis on which we charge. But in terms of percentage, I don't know about the percentage situation at all, Paul, to be honest with you, because the only situation I believe where a solicitor is entitled to by law charge a percentage is in a debt collection situation. Otherwise it's not permitted. Frank Trapp may have asked this question of you before, but just can't remember your answer. Similar to the last question, ever considering running employment law course like FETAC 6 or so? I don't know what's involved, Frank. I mean, I probably would, I probably should do it. It's probably something I should look into, and maybe you look into it for me and let me know, or give me a one-page dummy's guide to it. But I mean, it would depend, I suppose, on what's involved. It would depend on what I have to do, much time and so on and so forth. And I'm not sure about the accreditation, the FETAC 6, who does that and that sort of thing. But it's something that I certainly wouldn't rule out, you know. Foot clinic. In divorce, where I pay all the bills, school fee, mortgage, and in due course university, do I have to give her spousal support when she works part-time and I pay full child maintenance? In divorce, generally foot clinic, in divorce situations, you are going to make an agreement or have an agreement imposed upon you as to the future arrangements for support of dependents, including the spouse and including the children. So you either agree it or a judge will impose it. The bottom line is there is a legal obligation on spouses to maintain each other, so it's both ways, not just the husband maintaining or providing support for the wife, but the wife must support, theoretically anyway, the husband and the dependent children. A judge will not grant a divorce unless he or she is satisfied that proper provision has been made for all of the dependents, and that includes the wife and the children. The bottom line is, in terms then of you paying the bills and school fees and mortgages and so on and so forth, that's where the affidavit of means comes into being, and where the judge will have regard for the means of both parties, the resources of both parties, what they brought to the divorce or what they brought to the marriage in the first instance, who paid the mortgage, did you pay it but your wife was supporting you to the point where you could pay it because she was giving up her job, and so on and so forth. These are the issues that a judge will have to look at and will determine. The bottom line is that legally, as I say, there is an obligation on both parties to pay support for each other. But on divorce then, it depends what is agreed. J98. I am making some marketing materials for a solar company and I want to include an Irish Times article. Obviously I can't use the whole article, but can I include a link to the article and the headline? J98, you should have a look at the terms of use and so forth of the Irish Times website, because it is possible, I know, for them to prevent you linking to their website, and it's possible for them to prevent you from lawfully linking or using any of their links, or using a link to their website in your marketing materials. So if I was you, I'd be careful. There. Edwin, I think your videos are like a course at times. Well, hopefully. If you find this video useful today, please give it a thumbs up down below, and you may be interested in sharing with somebody. I've got a good few likes there now, that's good. Thumbs up, 20 thumbs ups, that's good. We'll be wrapping it up there shortly. It's nearly five minutes to go, so just waiting for one or two more questions, and that's really it. Thanks for showing up today, thanks for the support, thanks for supporting the channel and subscribing to it and so on. If you're not already a subscriber to my channel, by all means hit the subscribe button and click on there's a bell icon there, I think, where you'll get notified of new videos when I produce them or publish them. So that's it, we're getting towards the end there now. If there's any other questions, fire away, stick them in the box there. I'll do my best to answer them. Let me see now. Thanks Frank, thanks J98, Edwin Letterkenny, Worker 674829. That sounds like somebody working in a gulag or somewhere in Russia or someplace. But anyway, look, thanks for joining me and thanks for supporting the channel. The questions have ceased there now, so I think I will wrap it up. And as I say, thanks for your support and dropping by, and we'll be going there now shortly. Just see, is there anything else? Okay, have a great weekend, look after yourselves, and make sure to engage with the whole social distancing thing and so on. It's in the public interest, it's in all our interest that we kick the arse of COVID-19 and get our economy back to life and get our society back to life as best we can, and Shane Burke, hi Terry, how do you invest apart from property? I have a buttload of money in shares, and unfortunately the COVID-19 thing is after tanking them there in the last while, so much so that I'm actually afraid to go to the website to check them. So what I'm going to do is I'm going to take the view, when I was investing in the shares in the first instance, that I'm in it not for the quick buck but for the long haul, because I know that over a period of time shares actually perform very, very well. The difficulty with shares, investing in shares, is you need money. You can't leverage the same way you can with property, but that's what I've done, and I know over a long haul I'll be alright with the shares. They will give me a good return, and that is it. So I'll be wrapping up there now shortly. How many minutes have I done there now? 59 minutes ago. Again, thank you everybody for joining me, and thanks for the support on the channel. I'll be wrapping up there now shortly, and have a great weekend and look after yourselves. Alright, thanks a lot.